a slow start, I'll just commence with introductions. So thank you very much. Good afternoon, everybody. My name is Andrew Schaefer from Trafalgar. Welcome. Thank you for joining us. We've had an excellent response to this particular webinar, Unpacking the CSOS Directives. Over 600 people have registered, and it certainly indicates the significant interest in this document and particular topic. I'd like to start by welcoming our special guest this evening. First of all, I'd like to welcome Mervyn Doraisamy, maybe well known to many of you. Mervyn is currently the regional ombud for KwaZulu-Natal, Free State, and Mpumalanga. By way of background, Mervyn has an impressive collection of legal experiences. He's been a prosecutor, magistrate, and advocate, a member of the Special Investigating Unit. He's been principal legal counsel at the Competition Commission. He holds degrees in law and a master's of law. And in 2019, he was appointed as an ombud at the CSOS. He writes his desires to make a positive impact and create a just society evident in the work that he does, and really involving in community for common unity. So Mervyn, welcome. I know this project of the CSOS directives has been a special project of yours, so nobody better to join us tonight than you, and we're very grateful for your time and attendance tonight. Also joining us.
Thank you, Andrew. Thank you, Andrew, and the team. Glad to be here.
Also joining us this evening, we have Dylan Heerschop from Heerschop Pienaar Attorneys. Dylan is obviously an attorney. He specializes in law pertaining to community schemes and all concomitant compliance issues. He's based in the Western Cape, but has clients across South Africa. Dylan has spoken extensively on this particular topic as well. So Dylan, welcome. We appreciate you joining us and to share your expertise on this topic with us this evening. As usual, we've started promptly at 5. We'll end promptly at 6. We will certainly send the recording link as well as the slides that are presented tonight to all those that have registered for the webinar. So absolutely no need to ask for those. If any questions arise, please do write them in the Q&A. Karine and I will endeavor to answer. I will try and bring up any recurring questions or important topics to our speakers. So we'll do our best there. Any questions that aren't answered, there will be contact details at the end, and you would be welcome to make contact with any of us, and we will endeavor to come back to you. There will be a short pop-up survey at the end. If you have a few seconds to complete, we would appreciate you just rating the webinar, how it can be improved, and really any topics you'd like us to cover going forward. And those suggestions we do take on board, and we appreciate your input in that regard. Our September webinar is going to be on the topic of insurance, risk assessments, and the important maintenance implications for effective insurance for community schemes. So we look forward to presenting that one in the last week of September. Just a last point by way of introduction. Exciting for us, we are busy implementing a chatbot on Trafalgar's training website, which is the training.trafalgar.co.za. We've really tried to curate and collate a whole host of completely free training resources directed at trustees, directors, owners, and residents and stakeholders in community schemes. And the nice thing about the training bot, which is currently being trained and set up, is that it will be possible to ask any particular question that you have, and it will immediately, within seconds, give a informed answer with the links to the source of that particular question, and make it much more easy to find answers to your questions, to find support at the particular need that you've got. And really, it should be a whole lot more convenient to interact with the training material in that way. So we hope to make that available in 2 weeks, and perhaps at the September webinar, I will be able to demonstrate that briefly to you. So thanks once again for joining us. And with that introduction out the way, Mervyn, may I hand over to you? Thank you very much indeed.
Thank you very much, Andrew, Peter, and the team. So glad to be here, and it's so important that you are emphasizing a better understanding of the practice directives. I trust that I'm audible, Andrew.
Mervyn, very good, loud and clear. So you're good to go. Thank you.
Thank you very much. Thank you very much. It's such a privilege to be here. And it's also so important that CSOS is engaging with Trafalgar on a number of bases and reasons, and we meet with you on a quarterly basis. We're glad that you are holding us accountable as an industry player and an important stakeholder in the industry. So thank you for that. We just came out earlier today from a third in a series of webinars relating to the practice directive. And I believe, Andrew, that there is not enough emphasis that we can place on our practice directives, creating awareness and a better understanding. And it's engagements like this that will cause us to have that better understanding and allow people to engage. So we're really glad about that. Yes, it's important to unpack the practice directives. I don't really want to get into the history of the practice directives, the fact that it was fragmented and piecemeal, and we now had the opportunity of ensuring one complete consolidated manual dealing with all of the practice directives. So we had a sense of what they were, but also what the gaps were over the years. And what we could introduce by way of practice directives. Most of it is what's needed is legislative amendments, and we'll reach that point very soon. And I'll make some comments about that as well. So the consolidation is complete of all practice directives. If you've seen a practice directive,
Shame. Are you losing you now, Mervyn, on the bandwidth side?
in operation in the past, need to ensure that you look at the current practice directives and
All right, I've lost Mervyn. Peter, is that the same for you?
Same, Andrew. I think we should move over
Yeah,
possibly to Dylan,
yeah,
and then we can move to Moon thereafter.
exactly. Okay, Mervyn, sorry, we're going to just skip ahead to Dylan because your bandwidth seems to be unstable. We are losing connection. So apologies about that. So we'll just move seamlessly to your side, Dylan, and see if we can get back to Mervyn if his connection can stabilize. So over to you. Thank you, Dylan.
Thank you, Andrew and team. I really appreciate the opportunity. I think you guys do a lot for the industry, and I think there's a lot of pointers that a lot of managing agents can take from all of these leaps and bounds that guys have towards the industry. So yeah, I think it's a very topical thing that we're chatting about. I think Mervyn, started to introduce the fact that there used to be a bit of fragmented practice directives, circulars, all of these lovely things. I mean, personally, I had the perception of almost having to rummage around CSOS's website to try and, find the applicable directive. At some point, the smarter part of me decided to, save all of these directives on my own laptop so that I don't need to go and search for them. But I think it's a good step. If we can move on to the next slide.
Hi, Andrew. My apologies there. I really don't know what happened. Something is sabotaged. Can you hear me now?
Andrew?
Yeah, no, Mervyn, thank you. We've got you back. We lost you, so we had switched over to Dylan. So Dylan, with your indulgence, let's just go back to Mervyn, and then we'll come back to your introduction. So thank you.
My apologies, Dylan. Thank you for your indulgence there. Thank you very much.
Okay.
So we opened the process up for public comment, and we really trust that it went far and wide. And we got a great deal of input from industry players, from stakeholders, just from individuals living in community schemes. We took some of them into account and others were rejected. We even had public comments where a stakeholder is saying they would like to see A, but another stakeholder says, I don't want to see A because that doesn't work. So we had to grapple with a lot of the public comments that came in and indicate what is coming in and what is leaving, what we're leaving out. And we're ready to give feedback to those who had given us comments as well. It's important to know that the practice directives are in terms of Section 36 of our Act, And we have the primary legislation, and we must be able to give enough meat to it in our practice directives, but not, we can't introduce new law. It has to be subject and incidental to what our primary legislation is. We're also putting out that the way in which the stakeholders now engage with us is through the CSOS Connect. You know, we could have a 220-page practice directives, but ultimately it comes down to our digital service, the CSOS Connect. You may be engaging with it. A number of managing agents have registered schemes on it. A lot of them are experiencing challenges as well. We invite them to engage with us. So that's the platform where you get all of the information, and it enables you, it opens the door to all of your processes and applications. We're going to be 10 years next year in existence. And over the years, we've seen the gaps and the confusion and the ambiguous provisions that have been out there in terms of practice directives and legislation. And we invite everyone to always be considering the type of legislative amendments that you want to see. We have started the process of legislative review, but Andrew, we cannot leave anyone out in this journey of practice directives. We want everyone to have a say, have a sense of what changes they want to see and motivate for those changes. What we'll eventually see in the bill or in the final product, of course, we will have to motivate or accept it at that point in time. But all of us are going to go on this journey of ensuring legislative amendments. Thank you. On our next page of the slide, what I want to emphasize here is some general practice directives. We call it guidelines. Here we are expecting people to conduct themselves in a courteous, respectful, professional manner with CSOS, not to use defamatory or derogatory terms and language in their correspondence, but also we've warned our staff as well that cannot apply in respect of them when they engage with the public. There has to be internal dispute resolutions. Trafalgar, all other stakeholders, and everyone else will emphasize the point about internal dispute resolution. First, dispute resolution starts at the scheme. The more formal processes starts with CSOS. And so therefore we will ask parties, not only in disputes, but in any given application, whether it is scheme governance related for unanimous resolutions or approval of scheme rules, etc., we will ask, if there's a dispute, if there's a challenge or an issue, have you resolved it or attempted to resolve this point back home at the scheme in terms of your rules and in terms of meeting requirements? So start there with internal remedies and then come to CSOS. One of the important points we're making is that all parties are entitled to the other person's documents and submissions. And that must happen throughout. And if that's not happening to parties in dispute resolution, we want you to bring that to attention because it would be an unfair process. We want you to have a sense of what the other side is saying. You're always copied in so that you know what is before the adjudicator when the adjudicator simply sits with the file before them and makes an order on the papers. So you would be given every opportunity to do that. The practice directives are underlined by different forms, documents, and information. Those are available. We highlight those in the practice directives as well. Our practice directives are broken up into all of these chapters that I've said here. So this slide essentially tells you what's the contents of the practice directives. Now, in a sense, we have quite a number of aspects we're dealing with, but we start with disaster management. You know, if we're not going to take care of what happens during a disaster, then we're going to face it in the future. And we thought that we would do enough to bring out some basic aspects with regards to how CSOS will operate during disaster management, what is our business continuity issues, but also schemes. How do you operate? We can't regulate that completely because you have your rules and you have your MOIs and you have other things which you can use for the purposes of what happens during disaster management. And we're asking you to make that comprehensive, make it clear, and if it's not in existence, ensure that it is there going forward. We emphasize scheme registration. All schemes must register with CSOS through CSOS Connect, And that's an ongoing process now. And many managing agents are beginning to see that through the V&V process, where you are asked for your schemes, registered or unregistered. And of course, there's much engagement between our service providers in that regard and managing agents as well. Compliance and enforcement is really a big thing for us. And first comes compliance. You know, we want to see compliance on the part of schemes. And we set out a number of options that we could take. We're not going to take the hard line. We're not going to immediately call the police or report you to the NPA. You know, that's a far cry from what we really want for the community scheme sector. You know, we don't want to open a case at the police station. But ultimately, it comes down to that when we do get those powers, when we are able to do that. But now we encourage compliance. We give you a verification letter. We try and establish where are you in the scheme of things? At what level are you with compliance? And we begin to bring about some interventions which will allow you as schemes to do that. Now, we know that many schemes are running and operating really well. But there are many, Andrew, we have a bird's eye view of all of the schemes nationally. And we know the struggling schemes, the dysfunctional schemes, the mismanaged schemes. And how could we then, hand you over when we haven't given you the opportunity? There are public schemes, thousands and thousands of public schemes that have been inherited from municipalities. They do not even know what the concept of sectional title means, what a body corporate means. Why should I pay levies? So that's the reason we are encouraging compliance from the outset for all of these things. Then when it comes to scheme governance, there's a number of aspects there. You don't always play a role in it because sometimes these scheme governance applications that are made in terms of Section 6.9 or 13.2, and we've now opened it up for other schemes as well, like HOAs. If you have need the opportunity to apply to CSOS for the appropriate consent, for the appropriate approval for your unanimous, you can't obtain it back at the scheme, you want to introduce some changes or some measures to your unit or to common property or exclusive use area or your infrastructure in the HOA, you do not have the rules, you do not have the options available for you, you can apply to CSOS. Now, those steps highlighted in green are the ones that would be applicable to sectional titles, and we know predominantly it is sectional titles. We understand that we must cater for that. But what has happened in the past is that we've not placed enough emphasis on HOAs. So this practice directive speaks to HOAs in a great number of ways, where we introduce the options for other schemes, including HOAs, to also follow a similar type of process in coming to us, not applying Section 6.9, not applying Section 13.2, but their own general law rules, or just to approach us in terms of their MOI or any other aspect, or if there's an omission to govern that kind of route for them to take. So we have those options for other schemes to also approach us. But you will see there that you find the word voluntary there. Now, of course, that is what other schemes are saying to us, especially HOAs. You can't bind us to the CSOS Act and to the CSOS regulation. At the outset, we want to say all schemes fall under our regulation. We want those who are even required to volunteer rules to us to take advantage of our services and to take advantage of the fact that disgruntled unit owners and others, directors or trustees, wherever they are and whoever they are in the scheme of things, they can apply to CSOS for the approval or for consent where it is denied or it's unreasonably withheld. So we're giving you the option, and we are saying, even though it's voluntary for you to do some of these things, HOAs, come to CSOS nevertheless, because you'll see as well that HOAs are registering with CSOS and others are also doing what is necessary. And then we deal with the CSOS levies and the annual returns. We are open to always discussing it, how this works, and there's much detail in the practice directives for those things. We decided also to introduce and to make provision for executive managing agents, where it is mentioned in in Regulation 28.1 and 28.2. Now, this is important for schemes. For 28.1, we leave completely to them, and in 28.2, you consider looking at the CSOS panel of EMAs, where we have a code of conduct, etc. Now, we've even catered for the removal of the EMA, the appointed EMA, through a Section 39.7 amendment, where we make the Chief Ombud proposes a particular order. Now, one of those orders can be the removal of the EMA as well. Dispute resolution, CSOS is known primarily for dispute resolution. So we've placed a lot of emphasis on that. And some of those things I want to highlight now. Andrew, I also want to say very quickly that over the years, we have been rejecting a number of disputes which should not be rejected, because they do not fall under Section 39, but they come from schemes. They are related to issues at the schemes. And that's why when we look at the legislative amendments, we would like to broaden Section 39 to include a lot of the matters that we have been rejecting. I want to emphasize on the next slide some points regarding some significant changes. I've mentioned the EMA, and then there are undesirable rules for sectional titles and other schemes. This is the bare minimum of undesirable rules. Schemes must know that the drafting of rules must be constitutional, must be reasonable, proportional, and all of those things. And that's how it's going to be tested from time to time. We will only set out a minimum number of undesirable rules, and we would urge the community schemes to abide by the undesirable rules and to look at your rules when you submit them for approval. We want to emphasize today condonation. Previously, when you apply for the setting aside or declaring of invalidity of a rule or decision or resolution, you had to do so within 60 days. And that is still the case in terms of Section 41. But what happened before is that we made the decision for condonation without involving the other side, without involving the respondent. Now we introduce an odi alteram partem rule, where we will bring the condonation application to the attention of the other side and then make a reasonable decision based on the law and what is set for us in terms of the condonnations. Then, in respect of urgent disputes, it was never built into the Act itself. It was there in previous practice directives. We've now brought it into Section 39.7. It is a provision where we can make urgent orders within 48 hours, provided you meet the requirements for urgency, and that it relates to disconnection, restriction of electricity, access, danger, safety, and health issues. Everyone is going to mark their dispute as urgent. Everything is urgent. I understand that. We understand it at CSOS. But there had to be a cutoff of a category of selected urgent matters where we can give you an order within 48 hours. With regards to legal fees, certainly we stand by what we have put out in our practice directives, that the legal fees must be reasonable. But first and foremost, we are encouraging schemes to make use of CSOS. We do not want courts to kick out your matter because you've gone to courts to say, deal with my matter. We've had one or two decisions that said, why have you not gone to CSOS first as the regulator that deals with your matter? And so we expect people to not incur legal fees at the first choice, but to consider the option of filing their dispute application, provided it falls within 39 at the moment. Later, it'll be extended. If it falls within 39, to come to CSOS, especially the claim for arrear levies. Now, with regards to arrear levies, in the new practice directives, you would apply, Andrew, for the claim on behalf of the scheme for 40,000 Rand. Today, the outstanding levies is 40,000. But when the adjudicator makes the order in 3 months' time, that outstanding levies has increased over the 3 months. And the practice directives now says when the adjudicator makes the order, he can make the order for the 80,000 that's outstanding at the time of the adjudication. Why are we doing that? We're doing that because we understand the financial issues that schemes go through. We have to get them, the defaulters, to pay back, and we have to give them the orders that they require. But that process of making the order for 80,000 involves an engagement between the parties, and the adjudicator asking. He has a discretion to ask for the current bill. He may not necessarily ask for it, but you can, at the time of lodging. So that's why we say, when you lodge a dispute for arrear levies for 40,000, say that I'm claiming the 40 plus any other amount that is due and payable to me at the point of the adjudication, at which point I will provide the adjudicator with that latest billing as well. So that's important for the stakeholders to know. We've not received a great deal of criticism over that. Some would say, well, that's far reaching. Why are you introducing far reaching powers? We're understanding the financial plights of many schemes so that we can get them to pay. And then finally, in terms of 39.7, we've introduced just a few. Previously, when we wanted to plan for 39.7, we had an extensive 39.7 B powers, but now we've just put in the urgent, the undesirable rules and non-compliance with it, as well as the removal of the EMA. So those are the things I want to emphasize, Andrew. Thank you very much.
Thank you so much, Mervyn. That was very interesting indeed. So we will move back to you, Dylan. So can we continue on your side? Thank you.
That's perfect. So we can go on to the next slide. So thank you, Mervyn. I think a lot of stuff, I'll just run through a few things because I think Mervyn adequately addressed a lot of things. But again, as we said, I think the overarching principle, if we had to summarize the directive in one sentence, all of the old directives and circulars and all of these lovely things have now been consolidated into one single unified document. So we can move on to the next slide. So this is just a bit of a visual representation of what has been said in the past. We had these directives and circulars, separate documents, and they've all now been put together into this new directive. We can also move on here. So yeah, there's 5 chapters. Chapter 1 is registration and compliance. Chapter 2, governance and rules. 3, financial management. 4, dispute resolution. And then 5, the information practices. So let's just unpack a bit of these directives so we can move on. So the first chapter, and specifically when we look at registrations, as Mervyn already highlighted, we need to register schemes and submit annual returns on CSOS Connect. There is the undertaking of a turnaround time of 7 days after you've now completed your application and naturally provided that all of the correct information has been provided to CSOS, that the schemes would be registered. And then also a scheme must register within 30 days of receiving the certificate of establishment from the deeds officer. Yeah. Then when one looks at compliance, Mervyn also touched on this. So there's a tiered enforcement model. And I think I want to reiterate also what Mervyn said. I think in the industry, there's a lot of clickbait at this stage saying, the cops are on their way and they're there to lock you up. Based on this directive, I really don't, my interpretation and understanding of the directive is not that. It seems, that CSOS is really actively trying to ensure that schemes become compliant. And I mean, the fact that they do have the right, this right is not gauged from this directive itself. It comes from the CSOS Act, which says non-compliance of CSOS Act can attract criminal liability. So it's nothing new, but I really like the informal engagement where CSOS would most probably reach out to managing agents and industry stakeholders to try and, audit or proactively look towards ensuring compliance. Then it would escalate to formal notices, how these formal notices would look. I'm not too sure. The directive does not prescribe a certain notice, but one can expect on CSOS's letterhead something along the lines saying formal notices. And then if we don't comply, then we would look, CSOS would look towards referring the matter to the NPA. So yeah, we can move on this one. But I think just whilst we're moving on, I think the industry just needs to understand that it's not this matter of, CSOs now actively trying to see how many people they can lock up. So I think that fear, we need to shy away from that fear, and we shouldn't buy into those clickbaity, articles and situations where they're saying all of these things. So then just in conclusion, you guys may not have seen too much of me saying anything about submissions and returns. Nothing really has changed. What has changed is CSOS Connect and the emphasis on the fact that we need to use this platform. States of emergency as well. What we need to understand, we haven't really unpacked it because it is still the same. I think, the purpose of my portion of the presentation is to highlight the new things so that we know what's new. We all accept that the previous stuff, is to an extent understood. And then something that's awesome, and I want to compliment CSOS on it, is the process flow. So chapter 1 to chapter 4 has process flows, or, almost how-to type of guides. So, for example, in chapter 1, which deals with registration, there is a how-to guide in these process flows, which is like how to register a scheme. And then it goes from step 1 to step whatever, trying to help the general public understanding these things. And then if we look at chapter 1, had I, wanted to summarize it in one thing, I think the most important takeaway from this chapter is that CSOS is going to take a bit more of a proactive approach towards ensuring scheme compliance. So I think gone are the days where there's a dispute lodged with CSOS, and that is the point where some form of quality assurance or compliance assurance would happen. It is now going to be a more proactive situation during the governance period, and there does not need to be this dispute for CSOS to, make sure that schemes comply. We can go on to the next. So chapter 2, this is also a very interesting one. So firstly, I just want to address a bit on administrators and executive managing agents. Something that I think is awesome from this consolidated practice directive. It's the first time that CSOS seeks to codify or regulate, stakeholders such as administrators and EMAs. So in the past, we saw the letter of the panel of EMAs. So it's not the first time that we've heard of EMAs CSOS side, but I think this directive is the infancy stages of CSOS working towards a code of conduct, I can only think, for administrators and EMAs, and just trying to professionalize what it means to be these, accepting these capacities, and how we should, expect to deal with schemes and scheme administration when we accept these types of things. So a few things that is important to note from an administrator side. The first thing that we need to understand is CSOS needs to be notified of the appointment. I think there's an emphasis on the fact that, as the regulator, as the proverbial watchdog, as the person, tasked with ensuring that governance within a community scheme is lawful, reasonable, and, constitutional, surely CSOS should know that an administrator wants to be appointed, or of the intention to appoint an administrator. Then also in the directive, but this is merely a emphasize or a reiteration of what the Sectional Title Schemes Management Act says, that administrators need to submit quarterly reports to CSOS. So Section 16 already says that. So this is just, a confirmation, inclusion here, so that we don't need to, again, rummage around in the STSMA to see what we need to do. I think CSOS has done a lovely job with trying to, gauge from all of the different pieces of legislation and include everything in an understandable format. And then also administrators must cite CSOS as a respondent when we apply for this administration application, which would also mean that CSOS needs to be served with the papers, and CSOS then, can make the decision whether they want to become involved in this application or not. So those are some important things on EMAs and administrators. We can move on. So the next thing that I want to deal with in chapter 2 is the rules registration. So what we've seen from the past is, can you guys hear me?
We do, loud and clear, Dylan. Thank you.
Okay, cool. Perfect. So we can move on to the next slide, but it relates to the rules and being and quality assurance, basically. So what has happened now at this stage? In the past, we've all seen the circular on the amendment of rules, which related to specifically Sectional Title Schemes Management Act and Bodies Corporate, where they said, listen, we need to ensure that there's a certain set of rules and quality assurance mechanisms to deal with. What is interesting with the new directive is the fact that in this directive itself, it now regulates not only bodies corporate, but it also deals with homeowners associations, where there's a mandatory submission process of body corporate rules, but I mean, that's gauged from Section 10 again, so it's nothing new. And then a voluntary quality assurance process for HOAs. So, this to me, yeah, it's the next slide, Karim. So this to me would mean that when one looks at an HOA, and I think it's important to emphasize, the validity of the rules and the enforceability of the rules, barring undesirable rules, we'll get to that, does not, is not affected whether or not an HOA decides to make use of this quality assurance process. But CSOS still identifies undesirable rules for both bodies corporate and homeowners associations. And what is important to note that even, regardless of the fact of whether or not an HOA makes use of this voluntary quality assurance process, CSOS will not enforce a rule which equates to an undesirable rule. So whether or not we make use of this voluntary submission process, when we have a dispute with CSOS on an HOA side, CSOS is not going to enforce that rule if they are of the view that it's undesirable. So we can go on to the next slide. So we've highlighted a few. I think we skipped one now, but be that as it may. I just want to touch a bit on undesirable rules as well. So there's a few interesting undesirable rules. Yeah, I think I actually omitted the slide, but I'll just speak because I know the few interesting ones. So one that's very interesting, it's something new, it's very topical, relates to the fact that it deals with slaughtering of animals in an eco estate. So basically what it boils down to is when we have an HOA and it's in an eco estate or in a nature estate, CSOS does not deem it undesirable if we, for example, say we have a few impalas at the eco estate and you cannot go and run around with your knife and go and try and slaughter the poor impala that the HOA owns. That is not an undesirable rule. So I think the principle that we can take away from this, and again, it's such an interesting circumstances. I can only see some sort of dispute happening at CSOS that was used as a case study, but it's the principle in South Africa that we know very well is like a bring and braai. So the point of the matter is when we do these slaughtering activities, bring your own livestock when you slaughter them. So there is a few interesting things. Another interesting thing as well is the termination of electricity. So on the termination of electricity in the previous practice directive, it said they will not, or CSOS will not register any rule that refers to termination of electricity. CSOS has amended now to say that if judicial due process is taken, so the prescripts that CSOS says that judicial due process is that some sort of notice be sent to the owner of the intention to bring an application to terminate electricity, and then the application is actually seen through and a termination order is obtained. Then CSOS will register these types of rules. But any rule that says, a trustee is entitled to walk over to a DB board and simply switch off the circuit breaker and put a lock there and put a letter under the door saying, we're not going to reconnect, that is still spoliation. So the point of the matter and the change is that we can register rules in relation to termination where it speaks to judicial due process. So we can move on. The next one is the third chapter, which is the financial chapter. So the first component on CSOS levies itself, nothing has really changed very much. There's one important thing that we'll deal with at the end. We all know by now CSOS levies from 0 Rand to 40 Rand, depending on the amount of levies and the value of the property. So something that's important, the application for waiver of CSOS levies. So this is where CSOS does not automatically say you exempted from paying levies. It prescribes an application process for you to ask, which deals with situations where the monthly admin levy is less than 500 Rand, or any person earning less than 5,500 Rand net income. So that's after the taxman has come for their portion. If you're in those brackets, you can apply for a CSOS waiver. Then we come to the automatic waiver of CSOS levies, where it relates to firstly SASSA grant holders, and then a lot of variations pertaining to retired persons. So the first variation is retired persons in frail care, retired persons in assisted living, and then also retired persons in mid-care living. When we are these individuals, or if we form part of these category of individuals, we then have an automatic waiver of CSOS levies. But what is important, and I think this is the takeaway from this specific chapter on CSOS levies, is the changes to the submission of the levy schedules. So as we all know, we have to submit the levy schedules to CSOS. So what CSOS wants is that scheme executives in the levy schedules must indicate which units form part of this automatic waiver. So if we have SASSA grant holders, for example, Unit 2 is a SASSA grant holder, then in the levy schedule, we need to indicate to CSOS that this is a SASSA grant holder, for example. And then also the scheme executives, and I mean by proxy, that would mean the managing agents, who must keep a record of this, well, proof of this automatic waiver. So from a SASSA grant perspective, one would only expect some sort of SASSA confirmation that this person is a grant holder. And I mean, we can accept that the fact that we need to keep a record of these automatic waivers would suggest the fact that CSOS may at some point do some sort of audit or ask for proof so that they are also aware of the fact that these are in fact automatic CSOS waiver holders. So we can go on to the next slide. So this one is on annual returns. Again, nothing new. We all know that we must submit our CSOS annual returns within 4 months of a scheme's financial year end. And just something important that you guys should take note of, and you know, this is a very cool takeaway, I would say. What happens if this 4-month due date, we don't submit in this 4-month due date? I had a lovely conversation with CSOS where they said that the system is set up in such a way that if we are late, the system will not allow us to submit this annual return late. So that's not CSOS Connect malfunctioning. That's not a problem on CSOS's side. When this happens, CSOS says that there must be manual submission. So just take note of it. You know, it's an important thing that is not necessarily covered in the directive itself, but I think it's a very helpful tool that the industry needs to understand that if we are late, we need to do manual submissions because the platform is not going to allow us to submit it if we are late. We can go on to the next slide. So on the 4th chapter on dispute resolution, also a lot of exciting changes. The first change is the reinstatement of physical hearings on good cause shown. So we can get back to physical hearings. I always say, but maybe it's the attorney in me saying it, there is a talent, and as part of your right to adjudication, you need to be able to confront someone with the facts that they're putting in front of a forum. So ultimately, it's easy at this stage in the technological age to use ChatGPT and all of these lovely platforms, you know, to create a well-formulated argument. But the point of the matter is, if those are the facts or if those are the allegations put forth, whether you are the complainant or the respondent, the other party may or should be entitled to confront them with those facts and the right to cross-examination. So I think it's awesome that physical hearings are reinstated. Another thing, if there's connectivity issues, so if you are unable, you know, you have slow Wi-Fi or whatever the case may be, you can go to CSOS's regional offices and they will assist you so that you can attend a virtual hearing. And then something that I really like as well is adjudicators must confirm receipt of submissions and final written submissions. So this is nice for me. You know, it's just awesome knowing that someone has received it. It's not just emailing and wondering, you know, that my email perhaps bounced or my file's too big or whatever the case may be. It's good just to know it's in front of the right person and they have received it. So I think that is also an awesome thing that is in the new directive. We can go on to the next chapter or the next slide. Then also urgent matters and expansion of powers. I'm not going to take a lot of your time on this. I think Mervyn dealt with it very, very good. So firstly, there's a big focus on 24-hour periods. So CSOS will have 24 hours when we've submitted this form for urgent dispute resolution to consider the merits. You know, if they're happy or they deem it to be urgent, then the respondent will also have 24 hours to respond. And then when all of the documents have been settled, then CSOS, as Mervyn indicated, will have these orders within 48 hours. And I mean, these are things that need to be dealt with timeously. I mean, switching off someone's power unlawfully, we can just accept there's meat in a fridge, the meat is going off. It's just a whole rabbit hole that we're going down to if we can't have it adjudicated upon very quickly. Then also a bit of expansion of powers. So as I've alluded to, CSOS has the right not to enforce undesirable rules in terms of the directive or to order that a rule is undesirable. The next thing, and again, I need to compliment CSOS, this current levies component. I think again, it's an awesome platform. And the only thing that's important to take away, if we ask for the current levies, then we need to understand that CSOS will also then provide the respondent once again with an opportunity to respond. So let's say a financial year has passed and we've had a new AGM and a new budget, for example. As the applicants for these types of dispute resolution, we again have to comply with CSOS's and legal requirements to make out our claim. So I can only expect a new levy statement would have to be sent. If it's a new financial year, maybe the AGM pack and all of the docs accompanying the AGM pack to actually prove the current levies. Respondent will also be given an opportunity to respond to the new information that we've provided. And then the removal of an EMA. Mervyn has touched on it, so I'm not going to expand on that. We can move on to the next slide. Then Mervyn also touched on it, but suggestions when dealing with CSOS. So CSOS wants us to deal with them in plain English and no legal jargon. So sorry for all us attorneys, that love to use Latin and think we are very fancy when addressing whomever. I mean, sometimes I address my wife in Latin as well, and she doesn't appreciate it. So I can only expect nobody really appreciates it except us. Then something that's important as well, when we have dispute resolutions, we've all seen it where the respondent comes back and they have their own claims or counterclaims that they want CSOS to deal with. The CSOS Act doesn't cater for counterclaims. So if that person really wants that matter or that component being judged or adjudicated upon, they need to institute an application for dispute resolution. So it's important, keep a knot in your ear. If you receive some sort of CSOS thing where the respondent now wants to counterclaim something, just take note of it. Then adjudicators are permitted to seek clarity where he or she does not understand submissions. So it again comes down to, all of this legal jargon or perhaps, someone's line of argumentation not really being comprehensible. The adjudicator could be entitled to, just understand what you're trying to say. And then submission, forfeiture, and condemnation. This is also something new. It's not something new. It's ultimately CSOS warns you that should you have some sort of adjudication deadline and you don't comply with it, there's the risk that the matter will proceed in your absence. And then from a condemnation perspective, I think Mervyn has already dealt with it. Andrew, are we running out of time?
No, we're good to carry on. Thanks, Dylan. We've got 10 minutes.
Sorry about that. So on the code of conduct, I also think this is a very proactive step. So CSOS has now introduced a code of conduct for conciliators and adjudicators, what they expect of their conciliators and adjudicators. So, I mean, this is more for interest's sake. It's not going to change our practices, but it's good to know that there is a code of conduct. It speaks to impartiality and independence, confidentiality, avoiding conflicts of interest, professional competence, and respect. Then also equal opportunity principle. So both parties should be provided the same opportunity. Disclosure of prior involvement. If this adjudicator or conciliator has been involved in the merits of the matter, disclosing it to the parties, always communicating to both parties, and as Mervyn has indicated, also in a plain and respectful manner. Document decisions. Everyone wants to know why we get to a particular decision. Adhering to timelines. So CSOS uses the words reasonable promptness. So the adjudicators and conciliators are expected to be reasonably prompt in their dealings with these types of disputes and issues. And then also may not accept gifts, use position for personal or professional gain, breach confidentiality, or delay any proceedings unreasonably. So I think the code of conduct is a good step. Then again, as I said, the purpose of this presentation is not to unpack what the directive used to say, but when one looks at the POPI and PIA stuff, they basically identically the same to that we had with the prior directive as well. So it's not really changed in this bracket. If we can move on. Something that I also think is very important is the annexures are always look towards these things. It's actually aids for the industry, so you guys need to go and have a look at it. So Annexure A, list of supporting documents when you register a scheme. Annexure B is the undesirable rules for bodies corporate. Annexure C is those rules for HOAs. Annexure D is the application for consent for use of a section or EOA. We don't get the consent to change the use of a section, or we don't get the consent for an EUA. That's the application process. Annexure E has such a big, amazing word, but it's actually CSOS's banking details. So you'll see they have the banking details with all major banking institutions in South Africa. So it just gives you a list of their banking details. Annexure F is the list of supporting documents when you want to submit your annual submissions. And then Annexure G is the code of conduct that we just touched on. And then lastly, the process flows. As I've said, these are the how-to guides. How do we comply with what CSOS expects? So I think, it's always progressive to go and have a look at that. So I think, just to conclude with all of the stuff, I think the directive itself, marks the shift from fragmented compliance to this unified regulation. I think very important is compliance is no longer optional. Schemes must proactively align with CSOS's expectations, because it's not just going to be a dispute when CSOS looks towards whether we are compliant. They have this new compliance enforcement. I also think, this directive speaks to the digitization of CSOS governance. And I think, a good thing for the industry would be we would also have to digitize ourselves to comply with this. I mean, if we have to submit stuff onto CSOS's Connect platform, we might as well make our own lives easier by starting to digitize our internal governance as well. And then for me, I think it's a recalibration of CSOS's operational philosophy. So I know there's a lot of bad perceptions out there. It's a gross overreach, and I've seen a lot of bad, or people really not liking the practice directive. I don't think that should be the case. I think there's a lot of interesting things and a lot of beneficial things that we can gain from this directive, and we miss all of this if we simply stay into the negative comments about the directive. So yeah, I think that's it from me, my presentation. Thank you, Andrew. Thank you, Mervyn. Thank you, guys.
Thank you very much indeed, Dylan. Very, very interesting. Mervyn, can I come back to you just for a moment? And you spoke about legislative amendments. Can you maybe just sketch out what you've got in mind in terms of process and timing to get there, to address some of the opportunities for improvement or extension that you spoke about earlier?
Yes, thank you. So the legislative review process falls under the auspices of the Department of Human Settlements. We are an entity of human settlements, and we have to, regardless, follow this program of legislative amendments, which means that we first consider what we want to see, prepare some type of concept document, which we have, and we will continue engaging with it. We've not finalized it at all. We'll continue to have input from industry players as well as stakeholders, and that process of considering legislative amendments will continue for a bit. But what the department really wants from us right now, and which we are about to finalize by next week, is the social economic impact assessment. Now, this is a requirement for any legislation review that you want to introduce. You've got to talk about the socio-economic impact. We are doing that at present. Once that is done, we will submit that, and we will, I believe, get a certificate. It's good to get certificates. And we get a certificate that says we're good now for the next phase of engaging. We have a task team within CSOS and that we're looking at the legislative amendments. We have those that we were thinking about. We'll continue looking at that as we move along. Now, the program itself can be determined. At the moment, there's no timelines, but at some point, the department will say, submit at this point to the department, let the state law advisors look at it, etc., etc. But we know that much of that is going to be accomplished this year. Thank you, Andrew.
Okay, brilliant, Mervyn. And obviously the focus of that is the CSOS Act, is it, in terms of what you're saying? And is there a parallel process in terms of the STMSA and the other sectional title legislation?
That's right, exactly that. So it's a parallel process. We can't really do one without the other. We are the administrators of both acts, and of course, we see the gaps and the need for legislative amendments throughout. We're going to deal with it as one package.
Okay, perfect. And Mervyn, do you see yourselves updating these CSOS practice directives so as new opportunities arise to add, to extend, to clarify? Will this be a rolling update that you will see going forward?
Two things about that, Andrew. Thanks for the question. One is we're beginning to see some aspects of the practice directives in terms of typos, in terms of clarity, very basic and very simple changes that we want to bear in mind at the moment. But when we introduce the new legislation, we will then craft out a more permanent practice directive based on the legislation that we're going to introduce.
Good. And Mervyn, just a comment from you, because I think many of our joiners tonight are interested, just the process of capacitation of building your adjudicator panels and capacity and turnaround times in terms of the various functions of CSOS. How's that evolving?
Yes, thank you for that question. And a lot of the questions are relating to delays and backlogs at the moment. And it initially started when we were following a process of onboarding part-time adjudicators, an external panel, and we were doing it in terms of the HR process, similar to what the CCMA does or any other like-minded regulators. But we were required quite recently, I think, by the Auditor General to change that process to a procurement process, not an HR process of just inviting, interviewing, and appointing. But now, external part-time adjudicators need to bid and provide tender documents and become our service providers because of that requirement. And that caused somewhat of a backlog, and that initiated the backlog. And so we have a panel. Currently, we have about 33 external adjudicators, and a tender closed about 2 weeks ago for another supplementary panel. And we hopefully moving towards doubling that as well. Apart from that, we have about 6 to 7 internal adjudicators as well.
Good. And do they work nationally, Mervyn, or do you segment them by province? Because that's the structure CSOS adopted from the beginning.
Oh, yes. We have a national dispute resolution process, and that's why when you lodge a dispute in KZN or in GP, it doesn't stay with the conciliator there, it doesn't stay with the case officer there in that province. It moves around. The allocation takes place through CSOS Connect. It's automated, so it becomes anyone in the next line of receiving an allocation. And that's why there will be anyone around the country dealing with it. It is not incorrect that when you lodge a disputed GP, that a Western Cape conciliator will be dealing with it. Now, when it comes to the part-time adjudicators, yes, they operate nationally, but they report to our senior managers of dispute resolution. So we've grouped them into groups that can be managed by the various senior managers dispute resolution. Some of those are Renusha, Thora, and Shamaine. And they oversee and manage the part-time adjudicators, a group of them at a time.
Okay, brilliant. Well, it brings us to the end of the time we've got available this evening. So there's some contact details. If there's any questions outstanding or any follow-up required, you're welcome to contact any of us. We'll endeavor to get back to you very quickly. So thank you very much for joining us this evening. We appreciate your time. I'd like to thank our guests, Dylan and Mervyn. Thanks very much for your presentations and for just the insights into the practice directives, which is really a very big step forward in terms of clarity and support in terms of the community scheme industry. My thanks to my colleagues Karine and Peter for being the engine room behind these webinars. Much appreciated. And we hope you have a good evening, and we look forward to joining our next webinar in September. Good night, everybody. Thanks again.